Good morning, and thank you for joining us. We're going to spend some time today talking about the E-2 visa investor requirements and some renewal considerations. A few things before we get started. Some of you may know this firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the US personally on an E-2 visa, so has direct experience with this visa. The firm is a full service immigration firm, but we focus primarily on E-2 visas. We've processed hundreds of them, and we typically process E-2 visas that are higher risk, meaning lower investment amounts. We've processed at consulates around the world, but our primary two consulates where we process are Toronto and London. We will also continue doing this webinar series with at least 2 webinars a month on various immigration topics. At the end of this webinar, you'll receive a few things. One is this PowerPoint that you'll see today. Another is an E-2 visa guide that we've prepared, and also a link to where you can sign up for additional webinars. In terms of our panelists today, my name is Kelly LeGrand-Wiener. I'm the managing attorney at Scott Legal. We're also very lucky to have Dustin Saldariaga, an associate at the firm who has significant experience processing E-2 visas. If you have questions as we go through the presentation, please write them into the chat box. If it's kind of pertinent to what we're going over, we may answer it, as you ask it, or if not, we'll leave some time for questions at the end. And finally, this webinar is being recorded and will be made available on demand. So without further delay, I'm going to turn it over to Dustin to take us through some of the E-2 visa investor requirements.
Perfect. Thank you very much, Kelly. And thank you all for joining us today to learn about the E-2 investor visa requirements. So to start off, I'll start with this slide, which gives a nice overview of a few of the requirements, and then we'll go a bit deeper into each of these over the next few slides. So to start off, the E-2 investor visa is a treaty investor visa. What that means is that it is for individuals who are nationals of a country that has a certain treaty with the United States. It is a non-immigrant visa, which means that it is not a green card. It is not a permanent resident visa, and it does not directly lead to a green card or an immigrant visa. But it does allow nationals of specific treaty countries to come to the US to develop and direct the operations of a business in which they have invested. There are a few options for obtaining an E-2 visa. The most common example that we work with our clients on is startups. So individuals who have an idea that they want to invest in and develop and want a visa to come to the US to build from scratch. However, a startup is not the only way to get an E-2 visa. You can also purchase an existing business in the United States, or also fairly common is to start a franchise in the United States and work with a franchisor to develop a franchise in the US, a franchise location. Now, as I said before, there must be a treaty between the United States and the country of nationality of the applicant. Now, fortunately, first of all, many countries have E-2 treaties with the United States. I think at this time there are, I believe, over 80 countries that are E-2 treaty countries. So do check the US Department of State website, which keeps an active list of those countries. Odds are that your country is on the list. However, a few countries that are not on the list are China, India, Brazil, South Africa, and there are a number of others. For individuals who are nationals of those countries or any country that's not an E-2 treaty country, it is possible to apply for citizenship in a country through, for example, investment. So something we see with some regularity is nationals of, say, China or India who do want to pursue an E-2 visa, applying for citizenship through investment in a country like Grenada. And that is certainly a feasible option. Fortunately, for the E-2 visa, you only need the nationality of an E-2 treaty country. You do not need to have been born there. So If you apply for citizenship in Grenada, for example, you're granted it, then you would become eligible in terms of the nationality requirement. Finally, for how long is my E-2 visa valid? It spans from 3 months to 5 years. It really depends on the country of nationality. There's something called reciprocity. So depending on the agreement that the United States has with the country of nationality, it can span anywhere from 3 months to 5 years. So to get a little bit deeper into a few of these requirements, we've already talked a bit about the fact you must be a national of a treaty country. That is your nationality, not the place where you're born. You must make an investment. The funds that you invest into the business must be at risk. What that means is that they need to have actually been spent on legitimate business expenses. It's not enough, for example, to let's take an example, several $100,000, $500,000, and transfer it into a business bank account in the United States and apply based on that transfer. Those funds need to actually have been spent on the business, committed to the business. The source of those funds also needs to be documented for an E-2 investor visa. Now, fortunately, the government will really accept almost any legitimate source of funds, meaning lawful source of funds. So that can be funds that you've earned from work. It can be a gift that you've received really from anyone. It can be a loan. So really it can be selling property, selling an apartment, selling a home, selling another business. So really the scope is quite broad in terms of what the government will accept as legitimate and lawful. A couple examples of sources of funds that are not accepted are, for example, a loan that is secured by the assets of the E-2 treaty business, of the E-2 business. The funds need to actually have been distributed to the E-2 investor. So that investor needs to have received the funds personally, paid taxes on them, and then they can invest those funds into the business. But they actually need to have personal possession of the funds that are invested into the business. And one other note, and we will talk a little bit more about this. If the funds are from a gift, you do need to document how the person who made the gift received the funds. So if they worked for, say, 3 years, saved money, and then are giving the gift to you, they need to document that they worked for 3 years to get those funds. Now, the investment amount needs to have been substantial. We'll talk quite a bit more about this requirement. Typical E-2 expenditures are really legitimate business expenses. So if you take a step back and you think about what are all of the things that I need to spend money on so that my business is operational or ready to be operational as soon as my visa is issued, odds are that that is a legitimate business expense. So for example, you need inventory if you're selling things, you need equipment if you are producing things, or if you need computers to operate, odds are you do. Phones for the business can be a legitimate business expense. Office supplies are very common legitimate expenditures. An office lease, though not technically required by law, the government officers do like to see that you have a physical space where you'll be working and developing the business, and where any employees that you plan to hire will have a space to work. Marketing expenses are very common and a good business expense. Any professional fees to set up the business, legal fees are legitimate business expenses. And finally, and importantly, if you've spent any money on independent contractors or on employees, that is a key business expense, and you would certainly want to include that in your application. You'd show this by including in your application what we call an investment schedule, and that's really a spreadsheet that lists each and every expenditure that you've made on the business, along with a reference where you would point to the receipt for the expense, as well as proof that you've actually paid for that. So an invoice, say you pay for equipment at Home Depot, a popular store here in the US, you would have your receipt from the Home Depot showing that you bought certain equipment, and then you'd have your bank statement showing that funds were actually withdrawn to pay for that expenditure, and you'd include that in your application. Now, if you are purchasing a business, that list of expenditures can look very different from a startup, say. So if you're purchasing a business, it is possible to transfer the funds directly to the current owner of the business or the prior owner, and you would just document the transfer of funds as I just described, a contract for the business, as well as proof that the funds actually flowed from you as the investor to the seller of the business. One option that's available if you are purchasing a business and really making a single large purchase is an escrow agreement. So understandably, many applicants are concerned that what if I put a lot of money into this business and then my visa is denied? An escrow is really one of the only options that the government allows where you can back out of the deal and not lose money. So it is possible, and the government will accept if you have an escrow agreement. Let's say you're buying a business, the business costs $100,000. You would then enter into an agreement where you transfer that $100,000 into an escrow account, and the sole condition that's allowed on the release of those funds is that the visa is issued. So if the visa is issued, that $100,000 is released from the escrow account to the seller of the business. If the visa is not issued, the funds would come back to you. And again, the government will accept an escrow agreement as funds being committed to the business, as long as the only condition for the release of those funds is the visa being granted. Now, the third requirement you see on your screen is a key one. The business cannot be marginal. What that means is that the business must be able to support more than just the E-2 investor and their family. The business needs to employ U.S. workers. And what we usually recommend is that the business employ between 3 and 4 full-time equivalent U.S. workers within 5 years of being operational. I like to say that this requirement really can make or break an application. So if you have weaknesses in other parts of your application, for example, if you have a low investment amount, it is possible to overcome some of those weaknesses, such as a low investment amount, by showing that you actually have already hired workers. On the other hand, even if you've invested a lot of money into the business, if you can't convince the government that you're going to be employing workers, it can break an application and result in a denial. So the ability to employ U.S. workers within 5 years really is key. The business must be real and operating. Now, it does not need to be real and operating at the time you apply. Again, it's okay to apply with a startup, but what you must show is that once the visa is granted to you, you are ready to show up, to travel to the US and begin operating the business once the visa is granted. So there are ways to show that the business is ready to be operational once the visa is granted. You see a few examples on your screen here. Some of the things we would include in an application are that you have a signed commercial lease, you have space that you're ready to move into, that you have already created the business entity, the LLC or the corporation, for example, that you already have a website for the company, you're already marketing to customers. If you already have contracts that are executed with customers, or if you have letters from prospective customers showing that they are interested in engaging in business, purchasing your product or services, that can be key to show the business is ready to generate sales, generate revenue, and begin hiring workers. And finally, important to keep in mind is that if you're starting a certain business, that requires a license. So for example, if you're starting a restaurant, say, you may need a license from the state health department showing that you have gone through the steps to get a license to sell food where you want to sell it. So certain licenses, if they're normal for your type of business, it's good to show you already have those lined up at the time you apply. The fifth requirement you see on your screen, you must be solely coming to the US to develop and you will solely develop and direct the E-2 business on the visa. So this means a few things. First of all, when you enter the US on your E-2 visa, the scope of your work authorization is only to develop and direct the E-2 business. You are not authorized to work for another employer. So your job really should be to build that E-2 business. What it also means is that your role is to be an entrepreneur, or really to build the business. Your role is not to provide services directly to customers. This is much more important if you're applying domestically through USCIS for a change of status to E-2 status, in which case USCIS tends to be very strict about making sure that the E-2 investor is not the one who's actually providing services to customers. Rather, they really are acting as the entrepreneur. Consulates tend to care a little bit less about this. But the other way to think about this is that E-2 investors are not intended to be competing with workers in the US. So a quick example, if an E-2 investor wants to start an accounting firm, they are not supposed to be the individual who's providing accounting services to customers. They instead are supposed to start an accounting business, hire an accountant, who then is going to provide the services, because presumably there are people in the United States who are accountants and ready and willing to provide that service to customers. You must own at least 50% in the E-2 company. This is a threshold requirement. If the moment you drop below 50%, you become ineligible for the visa, even after you've received it. So if you sell equity, your ownership drops below 50%, you're ineligible at that moment. So you need to make sure you always have at least 50% ownership. And Kelly will talk a little bit later about how it is possible as a result to have two E-2 investors, as long as they each own 50% of the business. And finally, you need to have the intent to return to your home country upon the expiration of the E-2 visa. Again, the E-2 visa is a non-immigrant visa, so you do need to intend to return home. Now, the E-2 visa, government officials are a little less strict than with other visas. So for example, it is explicit in the immigration regulations that you actually don't need to own a home abroad to enter the US on an E-2 visa. So you can sell your home abroad and live in the US, but you absolutely cannot have the intention when you enter the US to adjust status and pursue a green card. So it is important to demonstrate to the government that you do intend to leave. And this is done usually by signing a letter, an attestation that just says, I understand I'm applying for a non-immigrant visa and my intention is to leave the US at the end of my status. So how much investment is enough? The government does not provide a bright line dollar amount and say, for example, with the EB-5 green card, there is a set dollar amount that if you invest that amount, you qualify based on the investment requirement. The E-2 visa is not like that. The government instead says that the investment amount must be quote unquote substantial. So what does that mean? Well, in some ways, it's negative in that you don't have, a clear dollar amount that you can say, I satisfy this. But on the other hand, it's actually a positive thing because it does allow you and your immigration attorney to make the argument that based on your type of business, you've invested a substantial amount, even if that amount is relatively low. And our law firm actually specializes in helping clients who have a relatively low investment amount pursue an E-2 visa. So it really does depend on the type of business. Kelly mentioned that our law firm was founded on an E-2 visa. A law firm is traditionally not an expensive business to start. The overhead is quite low. You need a computer, you need an attorney, even a part-time attorney to get started. So it is possible to invest a relatively low investment amount into something, say, like a law firm or a consulting firm. Now, what we would consider a low investment amount is in general anything under $100,000. And again, it depends on the type of business, but if you're investing under $100,000, we would typically look at that application and try to find other ways to strengthen it, such as I mentioned before, by hiring a worker, if you can do that before you apply. Now, the investment amount also can change depending on where you apply. Certain consulates are used to working with applicants who work for multinational companies and use E-2 visas to bring applicants to the US, sometimes dozens of employees. So if you are applying at a consulate that's used to seeing larger companies apply for E-2 visas, you are at a disadvantage if you have a lower investment amount. Other consulates, such as the consulates that Kelly mentioned, we typically deal with, such as Toronto, London, we are used to working with lower investment amounts, and it's more common for those consulates to see that rather than these large multinational companies. And finally, as I mentioned, the investment amount depends on the overall strength of the case. Again, you need to look at the application holistically. The investment amount is not the only requirement. So what the government does make clear is it will apply what they call a proportionality test. So what this means is that basically the more money that's required to start the type of business, the lower the percentage that the government will expect to see. So to take an example, our law firm, if you only need $100,000 to start a law firm, that's relatively low. The government will expect to see 100% of that relatively low investment amount at the time of application. So they'll want to see that all of that $100,000 has been invested. On the other hand, if you're starting a manufacturing company that's going to manufacture, say, batteries for electric vehicles, if the startup amount for that type of business is $10 million, the government will accept a proportionately lower amount. So say 20% of $10 million. They'll accept that $2 million investment rather than the full $10 million investment. If you do have a lower investment amount, you can use certain additional pieces of evidence to show that you've invested the full amount. So for example, you can get a letter from a CPA, a certified public accountant, that explains that based on their experience and their expertise, you've invested all the money that's required to get that type of business started. Also, you can go to your local Chamber of Commerce for the community where you plan to operate, and they can speak to the fact that they really do think that this is the type of business that would benefit the community, and that they do think it's a viable business. And finally, you can look at trade publications to show that for your type of business, the amount you've invested is a common amount, even though it is, say, $100,000 or less. When you're buying a business, typically the amount that the business is advertised at on the market, the fair market value, is a sufficient amount to invest in the business. And the government usually won't look deeper than that, as long as you can show this business was on the market and you paid the fair market value. Franchises are a good option for E-2 visas. Part of that reason is franchises tend to define how much the business costs to set it up. So they'll say, typically to start our franchise, it costs $100,000. And if you can show in the agreement that you've spent the amount that's usually required for that franchise, that's compelling evidence that you've invested a substantial amount of money. And we talked before about common good and bad E-2 visa expenditures. In terms of good expenditures, these are things that you need for the business to be operational. So inventory, equipment, employee payments, things like that, a commercial lease. Bad expenditures tend to be travel expenses, food expenses. If you come to the US, say, to look for a business to purchase and you include your flight in your investment schedule, that's a weak expense. Other examples of weak expenses, we usually would not include rent if you are using, say, space at your apartment. If you're renting an apartment and you use a room for your business, don't use your rent, generally speaking, as a business expense. Tuition is on the line. We usually would not include payments for, say, a university degree that prepares you to run that business, although certain trainings, if they're specific to the business, might be included. And finally, the other expenditure I would flag is a vehicle. If you're going to purchase a vehicle, it needs to be clear that it's necessary for the business. So do be careful if you're including a vehicle. You don't want it to appear that you are padding your expenditures artificially. You do want to make sure that you can explain to the government that this is something that's actually needed. Do I need to hire employees? Excuse me. The answer is that you do need to hire employees over the first 5 years of the business operating. And again, what we recommend is that the business hire between 3 and 4 full-time equivalent employees within 5 years of operating. You do not need to hire employees before you apply for the visa if you're doing a startup. So let's look at that a little bit. So basically, if you are doing a startup, the way you would show the government that you will hire employees is through a business plan. So a business plan is a key part of an application for an E-2 investor visa for startups, because it really is the key piece of evidence that shows what assumptions you are building this business on, and why you think you'll be hiring 3 to 4 full-time equivalent workers in the next 5 years. So a business plan is key. We do prepare business plans. We prepare business plans with an eye to what a consular officer or USCIS is likely to want to see in terms of what questions they'll have. You can prepare your own business plan. You can work with someone who prepares them regularly, but the advantage of working with an immigration lawyer to do that is that immigration lawyers are able to kind of anticipate the audience, which is a consular officer or a USCIS officer. If you are purchasing an existing business, you would then show that you can employ workers by looking at tax returns, by looking at pay stubs, pay records, and by looking at other tax records that show that that the business has employed workers. So let's say that you are looking to buy a business in the US. This is an important criterion for which business you'll purchase. If you're deciding between 2 businesses, let's say they're both $100,000, but one has existed for 10 years and has employed 1 worker, that's going to be a tough application, because you'll have to explain to the government why, in spite of existing for 10 years, the business hasn't employed 3 to 4 workers. Versus if you have another option for a business that has been operational for 10 years and employs 3 workers, for ideally more than 3 workers, that's a relatively stronger application, because you can say you're continuing that track record, excuse me, that company already has. So a common question is, do I need W-2 employees, or is it okay to have 1099 independent contractors? W-2 is just the tax form. 1099 is the tax form. W-2 is the tax form for employees. 1099 is the tax form for independent contractors. The answer is that the government does accept either of these. However, W-2 employees are certainly more persuasive, carry more weight with the government than 1099 independent contractors. So we would always recommend that if you can employ W-2 employees, do so. 1099 workers, if the business model, some business models only use 1099 independent contractors. If that's the case, you can apply based on that. It is generally acceptable. But again, if there's any way to have W-2 employees, we would encourage you to think creatively, even if it is as an office manager or as an administrative assistant. It's good to get employees on your payroll for the purposes of applying for an E-2 investor visa. I already touched on business plan considerations. Do I need a business plan? We would generally say you do need a business plan if you are applying based on a startup. Business plans are less critical if you're purchasing an existing business, because again, you can point to other documents like tax records to show that the business can employ workers. However, if you're purchasing a business that will pivot, that will do something differently in order to increase employment, a business plan can be key, because again, you're introducing new assumptions that would then generate revenue and result in employing workers. So what should be in the business plan? Well, an executive summary is key, because oftentimes government officials don't read every page of the business plan. So if you have an executive summary that's a page to 2 pages long, that gives them something that they can read through and see, okay, they're going to generate this much revenue, they're going to employ this number of employees by selling this type of product in this place. That's really helpful to the officer. The business plan should also show market analysis and research, who your competitors are, a marketing plan, how you're going to market your product or services. As we've discussed, a personnel plan that shows 5 years of hiring projections, including how much those employees will be paid, when they will be hired. It's not necessary that 5 employees be hired in year 1. What is important is that by year 5, again, you have 3 to 4 workers. So ramp up employment as early as you can, but if it takes a year or even 2 years to start hiring workers, that can be okay. A comprehensive financial plan is key for a business plan because, again, that's how you'll support your US workers. And finally, do I need to hire a professional? I touched on this before. We do have clients who opt to prepare their own business plans. I think what we've seen is that there is value to being able to anticipate what questions a consular officer or USCIS will ask. And when we prepare a business plan, we enter that process with the government official in mind, and we think that's important. So I will pass it off to Kelly now to talk a bit about E-2 visa developments and adjudication trends.
Thank you, Justin. Perfect. So we're going to get started just talking a little bit about some of the trends that we see in the E2s that we're processing. Regarding investment purchases in the US, this is a common question we get from clients as well. Do I have to spend money in the United States? And while it's not a requirement, like the legal standard does not require that you make the investment in the United States. For example, maybe you have a lot of inventory from abroad and you've spent a lot of money on that. That's a completely valid E2 expense. However, we have at different times noticed that some consular officers will ask how much money you have spent in the United States. Even though it's not a requirement, and so we prepare our clients to explain, if they had an officer that said, well, you need to invest in the US, we would, have them explain that's actually not part of the legal requirement. We think it is still helpful. The E2 treaty investor visa is meant to kind of facilitate, an economic benefit between the treaty countries. So it is helpful if you can show that some of your purchases are made in the United States. So even if maybe the main part of your investment, let's say, is inventory from abroad, then you also want to make sure that there's some expenditures you made in the United States. Perhaps you buy equipment in the United States. Perhaps, the marketing expenditures are made in the United States. We think it just is helpful for the application. So another thing that can come up with E2s at any visa application, but is being put into administrative processing. So when you go for your E2 visa interview, generally, they'll tell you right then and there if you are approved or denied. Another thing that can happen is that you can be put into administrative processing and you'll get a form called 221G. And a 221G is a technical denial. So you'll receive some documentation, either an email or a paper that says that your case has been refused under 221G. Unfortunately, because it is a technical denial, it does impact ESTA eligibility. So for any clients that are on ESTA, that's something to keep in mind. If you do get a 221G denial, when you have to reapply for ESTA and you have to answer the question, yes, that you had a visa denial, which can sometimes lead to your ESTA also being denied. So that is an unfortunate side effect of being put into administrative processing. When you're put into administrative processing, either you may need to submit some more documents, and if they want more documents, they'll tell you what they want, or they may just need more processing time. In that case, often what's happened is they're satisfied with the substance of your application, but there's some security issue that's been flagged. And it's not just the consulates. Any security agency can flag any visa application and put it into administrative processing. So it may have to do with those security checks, by other agencies besides the consulate or the Department of State. And unfortunately, when you're put into administrative processing, you just kind of need to wait until they've sorted it out. I'd say the majority of our clients are ultimately approved after being put into administrative processing, but it can be a frustrating process because at times it will take several months, even sometimes stretching on far beyond that. So it is just something to be aware of. Especially if you've traveled to any, countries with high security risks or anything like that. If you have anything in your history that you think might flag a security check, you want to make your attorney aware of that. So another thing we're seeing as just a result of COVID, I think to a certain extent, is more USCIS filings. We're now, 2 years, over 2 years into the pandemic. However, consulates are still recovering and are not really back to, where they were pre-pandemic in terms of processing times. Because of that, issues with getting visa appointments, and some consulates, for example, aren't like Bogota, are still not even processing E-2s at all. So because of that, some people are choosing to file from within the United States with U.S. Citizenship and Immigration Services. An approval with USCIS for an E-2 visa has some key differences from actually getting the E-2 visa that I think are important to highlight. So one is, let's say you're here, you're on B1 business visitor status, you've set up your company, you file your E-2 change of status application. What you're going to get is a 2-year approval that allows you to stay in the United States. It does not permit you to travel internationally. Once you travel internationally outside the United States, you'll have to submit a brand new visa application to a consulate abroad and get that granted before you can re-enter the US. You cannot re-enter just with your approval notice. Additionally, the E-2 is different than other visas like the H, the O, the L. For those types of visas, you get a petition approved with USCIS. And then when you go to the consulate is not doing really a substantive review of the eligibility. They're really kind of relying heavily on that approval to make the determination of whether you will get the visa. For the E-2, the consulates do not consider the approval within the United States. In fact, some consulates even view it, more negatively sometimes. Sometimes they don't believe that, that USCIS really knows the standards as well as they do. So it's not something where it's going to be a rubber stamp just because you got approved with USCIS. When you go to the consulate, they're going to look at the application with brand new eyes. And so you just want to be aware of that. If you do a USCIS filing, and some people do, they're fine staying in the US, they don't ever need to travel. You can do that, but there are, downsides. Something else to keep in mind with USCIS filings are they're more accepting of low investment amounts than some other consulates. So some of the lowest investment amounts we've processed successfully have been with USCIS. For example, even investment amounts, low into the, 40s, low 50s. That being said, those applications were very risky, and we made that clear to the clients. And as well, they also had lots of other strong factors to offset the low investment amount. So I think that's very important. When you have a case with a low investment amount, you need those other strong factors to offset that low investment amount. So then the other thing about USCIS filings, the last thing I'll say is just that if you're going to do those, they have a very, very strict approach to the source and trail of funds. They want a dollar for dollar accounting of everywhere your money came from. So if you have a very complicated source of funds, or you don't, you earn some money and it's been in a shoebox under your bed, it may not be the best to go with USCIS. They will often try to track dollar for dollar where the money is. Or has been, even going back, even if you say, you inherited it many years ago, they may even want to go back that far. So something to keep in mind when you're considering USCIS or a consulate. So, talking about the impact of the Biden-Harris administration, I think, there really hasn't been any major changes to e-visa adjudications that are caused by the administration. All the changes to adjudication have been caused by the pandemic. And similarly, in the previous administration, we really didn't see any, no substantive changes to e-visa adjudications other than maybe a bit more focus on whether a U.S. worker could be doing the job of an E-2 employee. So we haven't really seen no negative kind of impacts from this administration on e-visa processing. The impacts have all been from COVID. So then moving to COVID, in terms of kind of testing and vaccines, when you're talking about once you've gotten your visa, you're going to enter the United States, you always want to check the CDC website for the most updated information. Also, if you are in a situation where you're attending a visa appointment in a country that's not your own, where you currently live or reside. You want to also check the consulate instructions. Do they have, most consulates, what we've in our experience right now, don't have the quarantine requirement they used to have during the stricter lockdown parts of COVID, but it's very country specific. So you really want to kind of always be checking and making sure you're taking that into account. So if you need to kind of quarantine first, you would be arriving in the country early enough to allow yourself to do that. Or if you need to bring a mask to your interview, you make sure that you have that available. In terms of, consular issues that we're seeing, timelines are still extremely variable across consulates. Consulates shut down completely in March 2020. They have been reopening on an ad hoc post-specific basis since late summer of 2020. And as I mentioned, some consulates have not recovered enough even to process e-visas. Bogota is one that is not even processing them. There are some consulates that are, processing E-2 visas, not at pre-pandemic levels, I'd say, but pretty normally. London is a good consulate. Toronto is also a good consulate. Visa appointments may be more delayed than our clients hope for. Sometimes there's an ability to request an expedited appointment, but it's really variable. And then there are some consulates that are just extremely backlogged. You can expect, a wait of several months up to a year, sometimes more. Many consular officers have opined that it will be a process of years before they get back to pre-pandemic levels, partly because during the pandemic and during the prior administration, there was a lot of loss in the Department of State, a lot of staffing that, that is gone now. And so while they're training the new class of consular officers, it's going to take some time before they can get back to pre-pandemic levels of visa processing. And the E-2 visa in particular is a complex visa. So it's not a visa that, a consular officer who's brand new can just understand and start processing right away. So just something, another thing that we're seeing that unfortunately it likely will take some time, before we get back to where we were. Okay, so let's just talk briefly about some complex areas, for E-2s. Source and trail of funds for USCIS filings. I touched on this briefly in the previous slide, just it's going to be a dollar for dollar accounting if you're going with USCIS. For most consulates, it's going to be much more of a holistic high level view. If it's savings from employment, they just want to see your tax returns and proof of your savings account where you're transferring the money. I think Dustin may have touched on this earlier in terms of, loans and gifts. Loans are fine as long as they are not secured by the assets of the E-2 company. So for example, if you wanted to purchase a business and the seller is offering you some kind of seller financing, usually that is, in that case, the financing is based on kind of the assets of the company as the security. So that would not work for an E-2. Gifts do work, but it's not enough to just have the gift letter. You also have to show where the money came from. So if you're getting a gift from someone, you need, you need to speak with them and they need to feel comfortable that they're willing to give you the financial information. So if they got it from, savings from employment, they need to be willing to share their tax returns. If they got it from a, line of credit, they need to be willing to share that agreement with you, so that you can submit that to the consulate. Small investment amounts. So this is something that our firm processes. We process a lot of these types of cases. Some investments are just too small. Let's say, lots of people come to us and say, hey, I can start a consulting business for, $2,000 or $5,000. That amount is just going to be too small to qualify. When we talk about small investments, as Dustin mentioned, we're really talking about, investments of 100,000 or under. When you're trying to deal with these types of, issues for small investments, it's important to kind of explain why is this substantial in relation to the type of business you're starting. So, for example, provide market or industry reports from publications in your industry that support, the amount that you've spent and that it's fully sufficient to launch this type of business. It's also important to make sure that all the other parts of the application are as strong as possible. So, for example, make sure the real and operating parts of the application are strong, have a really, strong website have good marketing materials and a good marketing plan, have a detailed business plan with, financials that make sense, be able to show contracts or letters of intent with prospective clients who want to work with you. These are all really important when you have a small investment amount. Similarly, you can get, letters from local business organizations such as Chamber of Commerce that may say, that can confirm they've met with you and that they're excited to welcome your business, to the industry. Or if there's other business organizations you're a member of, that are supportive of the business, those can also be helpful to show that you've really done the research to run a successful business. If you're doing an E-2 visa for two investors, the ownership has to be 50-50. Ideally, you're investing an equal or mostly equal amount if there's two of you. And it's also good to make sure you each have a specific role within the company so that it, makes sense as to why two of you are needed. And another thing to note is some consulates will allow you to be interviewed together. So try to think about that when you're submitting your application. Substantive changes to the business after filing. This can take a couple of forms. One is a change in ownership structure. Always just be sure for the E-2 that the company is at least 50% owned by treaty country nationals. If it's not, then it will no longer qualify as an E-2 company at the time the ownership changes. Even if you have a valid visa, if the ownership drops below 50%, your visa is technically no longer valid because your company doesn't meet the requirements. If you yourself are the investor, your ownership should stay at least 50%, and you need to retain control, of the company. Another change we see other than ownership is a change in the type of business. If your type of business is changing drastically, let's say, you have a consulting company, now you want to open a restaurant. So you need approval for that new business before you can start operating it. If you had already, when you submitted your first application, described in your business plan that you were going to run a consulting company and a restaurant, and you had invested substantial funds for both lines of business, then you wouldn't need to go back and add, and ask for approval. But if you're just have been running a consulting company, you got approved for a consulting company, now you want to pivot and do something completely different, you do need that approval first. You need to show that the new business line is going to meet all the E-2 requirements. So for family business purchases, this is another issue that can come up sometimes. If you're purchasing a business, then usually the fair market value of the business on the open market is going to be considered substantial. If you're purchasing from a family member, inherently there's going to be more scrutiny, more attention paid to whether this is actually the fair market value of the business. So you could get a third-party valuation. You could provide financial documents, a letter from a CPA that explain why kind of it's a reasonable amount that you're paying. So, if the company is valued very high and you're buying in 50% at, $25,000, that's really not going to work. The amount you're paying needs to make sense in light of, the real value of the business. Okay, so common reasons for E-2 denials. So one is this low investment amount. There are times when, you just kind of can't get beyond it, even with all the other great, evidence that, that I talked about. So things you can do if you're denied on this point. So if you have more money to invest, let's say you had 100,000 to invest, you spent 45, the rest was working capital, you can invest more and reapply. So, asking what they were unhappy about, if they indicated they thought more money should be spent in particular areas, you can look at those areas, make expenditures that make sense for your business in the long run, and then reapply. Another thing you can do is kind of gather more evidence from industry reports, market research to support that your investment actually should be deemed substantial. And then you can also have a CPA review the business plan, review your investment schedule, and write a letter, kind of confirming that the investment is substantial in light of the type of business that you're starting. When you're looking for a CPA to help you with this, you want to, choose one who has experience in kind of the area that you're working so that their opinion will have more weight. Other things that can come up in denials are the nature of the business. So some businesses are just riskier than others. For example, for example, consulting businesses, sometimes officers are concerned someone's going to come in and be a solo consultant. And that's really not what the E-2 is for. You have to show that the company is going to be more than marginal. It's going to support more than just you and your family. To kind of combat that, if you're doing a consulting business, they're going to be concerned you're a solo. Maybe you hire somebody before you file. You also want to have proof of contracts so that they show you're going to work with multiple places. Sometimes people want to come in and just essentially be a consultant just working for one company. That's not what the E-2 is for. They really want you to be developing a more robust business. So you want to show you have more than just one major client. Maybe you do have one major client that's, the majority of your time, but you should also be marketing towards and trying to get letters of intent and contracts from other clients. Filing location can be another issue. Some consulates are very E-2 friendly. They have very developed E-2 visa units. Toronto is one of those. London's another. Frankfurt is another. But there are some places where they go through, consular officers kind of rotate over the years. Sometimes certain consulates become less E-2 friendly as the officers there develop a particular theory about E-2s. So it's something to keep in mind and speak with your immigration attorney about just to determine, if you have any options about where to file. You may want to try to file in a more E-2 friendly location if that's available to you. It isn't always available. Not every consulate will take, people that don't live in their country or are not nationals of their country. Another issue that can come up is if you, have a business in your home country without employees. Let's say you've run a consulting business for 10 years in your home country, and now you're trying to come to the US to run the same business. I think, you're going to inherently have more issues there because you have a track record of running this business without having hired anyone. So even if you have a strong business plan, they just may not believe that you actually are going to hire employees. So in that type of situation, you really, you may want to hire employees for your US company before you apply to try to, kind of get over that issue proactively. That issue that I just talked about is similar to the one below, concern over whether the business is going to create jobs for US workers. This is, just a really big issue for the E-2. The company needs to hire US workers. So, a strong business plan is really important, but hiring an employee, if that's possible for you, is also a really, strong boost for the application. If you may have an issue with the adjudicating officer, unfortunately, the officer has complete discretion over whether to grant or deny the visa. There is not an appeal process. However, being denied doesn't prejudice you against reapplying. And if you reapply, most consulates will try to make the effort to get you a different adjudicating officer. It's not guaranteed, but it's something to consider, that if you just felt like you got a really unfair, interview from a particular officer, you want to be as polite as possible. You want to ask what they were unhappy about, and then you can always try to reapply and address those concerns. Another reason for a denial is you just didn't meet the requirements at the time of filing. A file just didn't include what was needed. For example, we have had some people come to us that say they were denied, and when we look at their file, it turns out they had put $100,000 in a business bank account and not spent any money. So that, no money was at risk, no money was irrevocably committed. That file just does not meet the requirements. And working with those clients, we were able to advise them on what to spend money on. And then when they went back, they were approved. So that's, something as well as, I think a benefit to working with an attorney is just to make sure that your file actually meets the legal standard. So let's go to renewal considerations. What does it take to renew an E-2 visa? So I know I was, I mentioned this several times in the last slide. You have to hire US workers. This is just very key to getting approved. We recommend as a minimum, 3 full-time equivalents within 5 years. There's obviously going to be variation on that. And if you have, many companies, went through situations where they had to lay off staff during the pandemic. If over time, you had hired a couple employees, then you had to let them go. Now maybe you've built back to a few, part-time or full-time employees, I think that situation, can often be explained. But you do want to show a real effort made towards hiring. So if your hiring's on the lower side, you may want to, when you, reapply, show that you're actively, posting for new employees, that you're actively seeking out those new employees. So there's different strategies you can take, but ultimately, if you get to the 5-year mark and you haven't hired anyone, I think that renewal is going to be very, very, very difficult. I think most places, unless you were able to show some very significant economic benefit, the going forward without employees is just not going to work for a renewal. Other things you need are, updated financial data. So tax returns, consulates vary in terms of what they ask for. Some ask for all the tax returns since you last filed. Some ask for only the last 2 years. You want to consider, did your company meet its revenue targets? Is it profitable? What does your payroll information show? Can you provide information to show that you had that marketing and sales plan and it worked really effectively to get you where you wanted to go in the terms of the revenue? It's not a requirement. Consulates don't tend to ask to see the business plan you initially submitted and then look at that to say, well, did you meet your requirements? So, if you said, well, in year one, we're going to earn $400,000, but in year one, you actually earn $250,000, I think there's no issue with that. Like all they really are concerned about is the revenue growing? Is it going in the right direction? And are you earning enough revenue to be able to hire those U.S. workers? So that's really you want that to be your focus, when you're thinking about your renewal. If your company is, not doing well, you're not in a position to hire employees before you file to renew, you can kind of do some of those strategies I talked about. So, post job advertisements, talk about the hiring you did have in previous years and how the company is getting back on track to hire employees in the future. So another, when you're renewing, another thing that you're going to be concerned about is whether your company still meets the E-2 requirements. So that's where it's going to be relevant. Those ownership changes I talked about earlier, is the company still at least 50% owned by treaty country nationals? If you are the investor, do you still own 50% of the business? If there's been a change to the type of business, and it was really drastic, did you get approval for that? If it wasn't so much a substantive change as such, maybe a minor change, or maybe an addition that could be realistically described as an outgrowth of your previous business. So, you were a consulting company primarily focused on, marketing, and now you've added, kind of research and development. Like there may be things that are, you can just frame it as they're not substantive changes, they're just additions to your service line. And those things can also be explained in the renewal application.
Great. Thank you, Kelly. So we now can move on to questions and answers. We got a great question. I actually really like this question because it touches on a couple of issues. So Kelly, we were asked, we are German citizens. Normally, we would have to travel back to Germany and apply for the renewal of our visa at the U.S. Consulate in Frankfurt. So the person asking the question presumably already has an E-2 visa, presumably is already inside the U.S. And they ask, is it possible to apply for a renewal of our E-2 visa at a U.S. consulate in Canada? Is the visa process different in Canada than in Germany, and is it worth it? So Kelly, I'm happy to take this one, or happy to pass it off to you if you want to answer.
Well, I mean, so I'll take maybe the first part, if you want to take the second part. So, is it possible to apply for a renewal of your visa in Canada? Yes, that is possible. Canada does permit third country nationals, if you are resident in the US, and you can answer, yes, I'm residing in the US. Yes, you can apply for your renewal in Canada. Because you did not process there previously, so Canada has a registration system where they will register you when you get approved, and then you can go through a streamlined process for your renewal. If you are applying there for the first time as a German national, they may not allow that streamlined process. They may want to see kind of all of the initial documents that you submitted. So, in terms of kind of the difference, from Germany, there may be an option for a more streamlined process for you if you were initially registered. But yes, it is possible, to apply in Canada. And I don't know, Dustin, if you want to talk about kind of the visa processing process in
Yeah.
Canada versus Germany.
Yeah, absolutely. Part of the reason why I like this question is last I checked, which was about 3 months ago, Toronto had actually changed its requirements for a renewal. So the first thing I'd say is consulates change these requirements with some regularity. So if you're not working with an immigration lawyer, it's important for you to visit the consulate's website and get the most updated instructions for how to renew your visa. But again, last I checked, Toronto did offer a streamlined process for renewals, even if the initial application was not submitted to Toronto. So the process would, if things have not changed in the last 3 months, the process would probably be different in Toronto than in Frankfurt. Toronto offers a streamlined process for renewals, where basically what they want to see is that the business is generating revenue and employing workers. But again, those specific requirements are listed on the website. And I do want to reiterate what Kelly said, where you do want to be careful that Toronto or even Frankfurt is not going to have an issue with the fact that you got your visa in Frankfurt initially and you're trying to renew in Toronto. Okay, so another question rolled in. How long can one stay in the US with an E-2 visa? How long could the visa be renewed or extended? So even though the E-2 visa is a non-immigrant visa, as long as you remain eligible, the E-2 visa can be renewed domestically indefinitely. So if each time you renew, you get 2 years of status, as Kelly explained, and there is no limit to the number of times you can renew through USCIS. So if you have no need to travel outside the US, then theoretically you could continue renewing your visa indefinitely. The reason I say theoretically is because obviously USCIS, they are humans. This is a human who's reviewing your application. So the more time that passes where you've remained in the US and renewed your visa, the higher the likelihood they could ask, do you ever plan to leave? And, are you actually using the E-2 visa to stay here permanently? Again, legally that it is permitted, but there is always the possibility that an officer could want reassurance that in fact you do eventually plan to leave. But the answer to the question is that an E-2 visa can be renewed domestically indefinitely. Now again, I want to emphasize something that again Kelly touched on during the presentation, which is extending your status in the US does not give you the ability to travel. So you need a visa to enter the US. And you cannot receive an E-2 visa within the US. You have to receive an E-2 visa at a consulate. So if you have extended your E-2 status and you need to travel, be aware that if your visa has expired, you need to apply for a visa at a consulate before you re-enter the US. All right, the business plan that was submitted with the first visa application must be completely mentioned in the renewal with the current status of the business. So Sandra, that depends. So it depends really on the requirements of the consulate. Typically, a consulate, if you're applying for a renewal, doesn't necessarily require that you provide the business plan that was initially presented. Some consulates will want to see the initial application. They have a right to ask for that. And if they do ask for that, you should provide it. But based on what I have seen, consulates tend to be interested at the renewal stage. They tend to be interested in how the business has done over the last 5 years. And what that comes down to is, has the business generated revenue? What Kelly said, has it generated revenue sufficient to employ 3 to 4 full-time equivalent US workers? Has the trajectory of the revenue been positive, so in other words, is revenue declining, in which case you may need a business plan. But if the business is generating sufficient revenue to employ workers and it shows a positive trajectory, usually you would not need to provide a business plan again at the renewal stage. So I think that covers all the questions. Kelly, was there anything else you wanted to add before we say farewell to everyone?
No, I think that covered everything. And someone is asking now, it's one last question.
Yeah.
Should the case arise that an E-2 is rejected and the existing visa is expired, can one return to the US with a valid B1, B2? I think, potentially, but if your E-2 visa application was rejected and you're trying to enter the US right away after that on a B1 or B2, I think you can expect pretty significant questioning. There's likely to be significant concern as to whether you're going to come back and work unauthorized. There would need to be some explanation about why you need to come back and proof of when you chose to leave. For example, if you were coming to dissolve your company, you'd want to have kind of proof that you've gotten that dissolution in place. I think traveling back right away, could be difficult. So something you'd want to discuss, in more depth with, immigration counsel. All right. So thank you so much.
Yeah, thank you very much, Kelly.
All right. Have a nice day.
Thank you all for joining us and spending time with us. So keep an eye out for the email we'll send with a link to the recording and future webinars. We hope to see you there.
Thank you.
Thanks.